Katrina Shanks.
Thank you, Mr Speaker. It's my pleasure to take a call on the Family Court Proceedings Reform Bill this afternoon. The best outcome for all families who are going through tough times, conflict, separation, is to find their own solutions, to find their own resolutions, to make them sustainable and enduring for their own families. But we know that roughly 90% of New Zealanders manage to do that. Their families find their own resolutions and sustainable outcomes. And about 10% of New Zealanders, roughly, have to use the family court system. And for those 10% that use it because they can't find their own resolutions, they need a bit of help. This is where the government can come in and support these people. And what the Family Disputes Resolution does is give them another way to find that resolution. And we're doing that by allowing them to stay out of the court system for as long as possible, to give them access to parenting courses, to allow them to have somebody work with them to see if they can find some resolution, and to resolve some of their conflict. And then if they need to go into the court system and use that court system. And of course there will always be a safety net for those that are vulnerable or at risk to be able to go straight into that court system and use it. But those that don't need it, this is to assist those people. We had about 64,000 people in the 2011-12 year who were applicants to the Family Court, and we know 40% of those were made under the Care of Child Act. So about 26,000 applicants went through the family court system, which involved children. So we're here today to debate this bill about giving a solution to keep people out of the court system, families who are in conflict out of the court system, because from all the submissions that we heard, one thing that we did hear from those parents that came in to talk to us about their experience was that it's timely, it takes a long time to get through it, it's very expensive to get through the system, and actually they kept on going back and back and back into the court system, and it wasn't good for the children, it wasn't good for their relationships, and actually in many instances the outcomes weren't sustainable. So this is to offer an alternative to that, to offer an alternative. So some of the main issues raised through the submission process was the ability to access legal aid, was access to lawyers for the child, to allow a screening process for fast-tracking those who were vulnerable, the ability to refer parents back to the FDR from the court system. So if you've gone through FDR, you get to the court system, can the court send you back again for more parenting courses, or can send you back again to resolution? To allow relationship counselling to be part of the tools for the FDR. The importance of parenting courses, we heard that over and over again through our submitters, how important those parenting courses were to understand what the needs of the children are when you're going through that. It's not necessarily the needs of the parents, but the needs of the children and putting them first when they're making those decisions. The lawyers' involvement in the FDR system was what we heard of a lot, but then 46% of the submitters were lawyers, so that was most probably reflective of that. And also the skills needed in the FDR system. Who do you need in that process? Do you need an arbitrator? Do you need a dispute resolution person? And every family may be slightly different with slightly different needs. So we listened to all these concerns and we addressed them before the bill came back into the House. Mr Speaker, I think this is a good new system in place to allow families to stay out of the court system for as long as possible, and I look forward to the debate in the future. Thank you.
Speaker.
Honourable Phil Goff.
Mr Speaker, the Labor